A committee of Parliament recommended to the National Assembly that Dr. Hlophe be removed. Now, and in that committee, there were all sorts of people conflicted, but that's another story for another day. An interdict would violate the NA, the National Assembly's authority. In other words, what the court would be saying is, we understand your decision, but your decision must not be implemented, because all the members you have designated must not perform the functions that you have assigned to him. So if the National Assembly wants a feedback from the 6 members of the National Assembly of what happens in the JSC, Dr. Hlophe won't be part of that. And that can't be right. The National Assembly is entitled to the experience he has as a judge, is entitled to the full use of that experience. Let me close with the issue of costs. Dr. Hlophe must be awarded costs. He's here not because he wanted to. He's been dragged here. So whether he loses or he wins, he must be given costs. And the cost should be a cost of 3 counsel, especially for the gratuitous insults that Judge President Hlophe subjected to. To say that we make unethical submissions or unethical legal arguments is below me. I mean, I'm not going to, in fact, even talking about it, I'm not going to dignify that, because it's not made by Ms. February. If it's in the affidavit of Ms. February, but I do not believe Ms. February would have made that averment without the advice she gets, because the advice she gets is from lawyers who know this case, who say to him, the arguments made by Dr. Hlophe are unethical. We get targeted for those kind of insults. What unethical submissions have we made? They don't point them out. It's not fair that they don't love Hlophe and we don't expect them to. But why target his lawyers?
Just one question there, Mr.
Yeah, no,
Masuku. Regarding your averment, whether he wins or loses, what about the usual rule of costs following the result?
It's not unusual for, especially the NGOs, to make that kind of prayer for the courts to consider. I'm making the call for costs even if he loses, because Judge President Hlophe is not brought himself here. The cost he has incurred to defend this case is because he's been dragged to the courts. If he had not defended the case, you would be asking the question, but he's not defending it, so what? If he had simply said, no, I'm going to stay as a member of Parliament, the courts can do whatever they want. We are really here to assist the court to come to consider a good decision on whether an interdict is warranted, or even an order declaring the National Assembly's decision is constitutional. He has had to incur costs that he didn't have to incur. And this is how they drain you out. They will consistently litigate against you. And I'm sorry, I mean, you know, this is what happens when in this world of theirs, that once you are a target of their fancy, they will consistently without flinching attack you, drag you to court. In fact, we do have it in the FUL, that at some point they want to claim all the costs that were paid by the state against Judge President Hlophe. So if the similar approach to the Zuma case, where if the costs that Hlophe incurred defending himself were amounted to 30 million, so FUL will be doing that. The point is drain him financially. Whether he wins or loses, the courts are like to say our NGOs, BioWatch, we had an interest in the Constitution, we're defenders of the Constitution. What has Hlophe been doing here? So I'm saying it's important, in the principle you put to me, my lord, would not be fair towards Hlophe. And because you have a discretion, you have to consider how Hlophe has been treated here. He's asked to repent. He's a disgraced judge. This is another platform for berating him. He's moved out of the judiciary. He's no longer a threat to their interests. But so why continuously drag him to court when he's now performing his functions in a different role? I think I have managed my time well. If I say I stop here, but before I do, let me see if there is anything I am leaving out. Yes, even the allegations that Dr. Hlophe is using Stalingrad approach. Just with reference to the cases that have criticized litigant for being Stalingradist. Just do an analysis of the cases he has brought to court, why he has brought them, how he has brought them, compare and see whether there was any Stalingrad approach. Besides, Stalingrad presupposes that you have money. He doesn't. The Supreme Court of Appeal case had to lapse because he couldn't raise the 600,000 that was required. And yet they insult him and call him, because remember, he's a former judge. You're looking at your colleague, a former colleague, sorry. And what they are trying to present as your former colleague is somebody who's totally unethical. Other than the fact that he was disgraced by the JSC and removed in the way he was. Look at him again. He's coming to you with a Stalingrad approach, abusing the court. How is he abusing the court? By being here? Or by being in the court that they have been participating? Not on the basis that they are complaining about Stalingrad, but on the basis of the merits themselves. So in every case we've dealt with FUL, there have been merits that have been debated. When Hlophe loses, he loses not because his arguments are what they call unethical. It's not the right way to treat colleagues, to call their arguments unethical. And this is what they are saying. And they quote somebody, the reference they are making is a reference to Owen Rogers. It's not right. And I think it's important that you realize too that what Dr. Hlophe has complained about is the imprecise pleading that is raised in the founding affidavit of what they say he's wrong for. And when Dr. Hlophe complains about it, they then give a reply in which they start to give examples. Here is the example, here is the example, here is the example, here is the example. That's not how pleading stands. If you allege that I'm doing Stalingrad, tell me which cases you're talking about, so I can respond. If you say I'm raising unethical arguments, tell me which those arguments are. Don't just raise a statement insulting me. And this is why I think it's important to give an order, whether Hlophe wins or loses, an order that his costs are going to be borne by the FUL. At least, FUL from the website, they get money from very affluent organizations. Honorable Justices, these would be the submissions for Dr. Hlophe. There is no basis for an interdict to be granted, and that application should be dismissed with costs. There's similarly no basis on which the National Assembly's decision to designate Judge Hlophe as a member in the National Assembly in the JSC should be revoked or revised or set aside. We would ask that the court gives that order. But sorry, final submission. Just 1 minute. Judge Presiding asked the question about whether the dismissal, whether in relation to the two applications, the fact that FUL is asking for a final order, and what should be, or how it should be dealt with, and whether the DA is asking for an interdict. If you dismiss the interdict, which you should, which you submit, you should, then we submit that for the purposes of Judge President Hlophe, that would be it. If you decide not to deal with the FUL's case, then you don't deal with it. Although arguments have been advanced, probably would pretend that you deal with it. But the complaint raised at the beginning was a valid complaint that these cases should not have been running on the same courtroom. Precisely because now we have three cases where there's got to be some understanding of how you would deal with it. So if you hold that the National Assembly's decision was unlawful, then perhaps an interdict won't be necessary, because once you set aside that decision, what is the need for an interdict? Because Hlophe, that means the decision on which Hlophe would have gone to the JSC is no longer there. The interdict is no longer necessary. So if you uphold the FUL's application, then the interdict must similarly be not necessary. You only give an interdict against Dr. Hlophe if the argument is that, irrespective of what this court says about Part B, Dr. Hlophe will be seen in the doors of the JSC, which is obviously would be a ludicrous suggestion. Dr. Hlophe intends to play a very big role, and that role, I'm sure, terrifies others, but it makes others a bit more happier, especially MK. What they are asking this court to do is extraordinary. If the National Assembly were to today elect Dr. Hlophe as president, because the president appoints judges, they suggesting that there would be a basis for another inquiry into how you appointed a president who was a former judge. How should you do that? Because he was impeached. So if he's going to appoint judges, so 165 is implicated. No, I say that with tongue in cheek, but it's not too far-fetched. If he's appointed, if the National Assembly votes him as a president, these arguments will come to haunt us again if the court doesn't make a ruling in our favor, which is that this application should be dismissed. Those are the submissions.
Thank you, Mr. Masuku.
Thank you. I'm sorry, Judge. I didn't ask my opinion. Thank you.
Mr. Hlophe.
Good morning, Justice Parker, my lady. Proceed.
Yes.
Thank you very much.
We have 15 minutes before tea adjournment.
Okay, so let me.
Adjourn at 11. But you may proceed.
Yes. Okay. Yes. Well, if the need arises, I'm going to collect all my credits from starting from the emperor.
Let's leave the credits
to this but there's also a charitable reason why that should be considered, because I'm going to allow one of my trainees to deal with a specific issue. So that's why I was saying the 15 minutes that you're talking about is perfect, because then I can do the introductory part. Maybe just to set the scene. Now, this matter involves, everyone has said, complex, novel, all sorts of adjectives have been used to describe it. But, and there are many sections and subsections and topics and subtopics and so on. So I'm just going to try to do a signposting of some sort, so that there's a logical flow to what we're about to present. A lady, my lords, ultimately, and I'll deal with this when I deal with the merits, there's only one real issue that permeates the entire issue, and that's the issue of rationality. And the reason for that is that this entire case is, I mean, at face value, even people walking in the street who have never seen the door of a law school will tell you that there's something fishy about this. Why would the court want to deal with what is happening in Parliament and so on and so on? So they might not know the words separation of powers. But they'll say, but this thing was happening in Parliament just now it's happening in a courtroom. What's going on in this country? So the separation of powers permeates everything that is around this case. Everybody, literally, that I've spoken to about this, from Uber drivers and anybody, ask the same thing. But Parliament has done this thing. Why are you busy debating in court? This court, or the court in South Africa, should never allow itself to become the appeal tribunal of the National Assembly. Because that's what is being done. Our courts are being turned into a joke. A political party goes to elections, wins 20% of the vote or whatever, it goes to Parliament, where it should go. It objects to the designation of Dr. Hlophe, as it is entitled to. It loses the vote in the Parliament of the people. And then what does it do? It runs to court. What is that? They say with a straight face that as soon when that vote happened, they went to their lawyers. That's what they say in their own affidavit. So the trigger to this application was the losing of the vote in the National Assembly. Imagine, close your eyes and imagine if the DA had taken that debate to the House and won. Would you be here? No. Even a 3-year-old child will tell you that. were only here for one reason and one reason only. They lost a democratic vote in the parliament of the people that represents all of us. This is not parliament. You are not elected representatives of the people. How can unelected representatives of the people be the appeal body for the represented people of the representative, the body that represents our people? How can that be? What is that? We have elections here. The only reason we have something called parliament is because we can't all 60 million of us, every time we make a decision, we have some mass meeting of 60 million people. So we have representatives, but those 400 people are us. They are us. So when they take a decision, South Africa has taken a decision. That's it. There's nobody, it doesn't matter what you are called, whether you are the Chief Justice or the Chief Magistrate or the Chief or the Speaker or whatever it is. You cannot overrule the will of the people of South Africa. The people of South Africa have a right to be wrong. And nobody can do anything about it. If they elect me to be whatever it is, you may think that I'm the most useless person or whatever. But there is nothing you can do because the people of South Africa have made that mistake. It will be one that we have to live with until the Constitution says it must be rectified. Anyway, so we have what is this thing called rationality? See, rationality is not what we say when we talk in the street. That's irrational. No. In the legal world, rationality simply means whether the process that was adopted by the National Assembly accords with the purpose of the provision. That's all. Now, you've not been told what is the purpose of the provision, and you've been lied to as to the process. The process is very, very simple. The Speaker of Parliament, nobody has dissented from what the Speaker is saying. The Speaker says, we did not rubber stamp the decision. And the Speaker doesn't even have to say that, for God's sake. It's in the record. It's in the record. It's all over the record. Justice Bakwa said yesterday to one of my colleagues, are you saying that they debated the issue, but they fell short? In other words, they only dealt with the issue of the qualifications. But that is not borne out by the record. The record actually shows the exact opposite. The issue of the qualifications was not debated by anybody. Everybody, even those who hate Dr. Hlophe, said, we accept that he's an excellent jurist and is well qualified. We accept that. So that issue was never debated. The only issue that was debated in Parliament was the issue of the impeachment. That's what that debate was all about. For the first time in 30 years, the Chief Whips Forum said, let's take this thing to the House. Why? Because for the first time in 30 years, we were not agreeing in the Chief Whips Forum, as we normally do, that it's automatic, that somebody, once there's a referral by a party, it's automatic. For the first time in 30 years. And because they could not agree, not about qualifications, they couldn't agree about the issue of impeachment. They said, let's take it to the House. I think it was Honorable Frolic who used the best word. Said, well, it's the first time this is happening. The House is the arbiter. That's what he said. So let's take it to the House. For what? For a debate. So how can anybody, FUL, comes here and says, I think it's paragraph 2 of their heads of argument, we are here because the Parliament failed to consider, they use that word, underline that word. You're going to hear a lot about it. Failed to consider. That is a complete distortion. Parliament, whether they came with a right to the right conclusion or whatever, but how can you accuse them of saying you failed to consider that exactly what they considered? Everybody stood up there and said, oh, we've never had this situation about an impeached member, The word impeach is there. So that's all they were debating. So they considered, you as the judges are not allowed to go beyond that. Once Parliament discharges its duty to consider, it's not for you. Let's say they consider and then they come out with the wrong decision. That's not your job. Your job is to say, did they consider as they are required to do? Yes or no? If they did, they did. And they did. And what you must do is to go to the speakers for shorthand instead of going to the record. If you just go to the speaker's explanatory affidavit, you'll see there, I think there's Mr. Vessels, I think it's from the Freedom Front, who says that there's no legal impediment to this, but ethically I'm against it. There's a Mr. Maimane, who says that this has never happened and there's a lacuna. There's a Mr. Swart from the ACDP who says that there's no legal impediment, but we are seized with this matter. There's Honorable Shivambu, who says that the convention, who talks about the convention, and then there's I think it's Mr. Machakis or something from the DA, who obviously says what the DA is saying. But here are two telling things which I wanted to mention before we go to tea. One is that the DA, if you go to, to the speaker's explanatory affidavit, which you'll find this particular reference is it's TD4, which is the it's actually the minutes to the Chief Whip's Forum.
We have it.
You have it. Okay. Let me just paraphrase. I'll find the case line reference. Mr. Machakis. Oh no, Mikalakis. Sorry, Mikalakis. Yes, from the DA. This is what he said. Now they come here and say something completely different at the Chief Whip's Forum. Say. Mr. Shivambu indicated that the previous meeting it was proposed that it's 05-84, sorry. It was proposed that a political party should not interfere with the nomination of another party. There was no objection and so on. Mr. Nguban expressed surprise that there was disagreement. And then here's the DA person. Mr. Mikalakis stated that he agreed in principle that parties should not interfere with each other's nominees. But in that specific case, his caucus, that's the DA caucus, did not agree with the candidate for moral reasons. Moral reasons. We must sit here, all of us, honorable judges and so on, because some party had moral objections. And between down here, where there's parliament, and this building, it changes to a legal reason. No. So this is a political, as the speaker says, it's a political decision. And it is not true that what was put to my learned friend, I think Mr. Masuku, that the political decision was the MK decision. No. The speaker says the decision by the National Assembly to designate Dr. Hlophe is a political decision. It's a political decision. By the way, the decision to impeach him was also a political decision. So let's not elevate it as if it's some godly decision that says that objectively Dr. Hlophe is a person who has got some inherent wrongdoing. It was a political decision. If that impeachment happened now in this parliament, Dr. Hlophe may not be impeached. So it was a political decision by a particular balance of forces which was dominated by the DA and the ANC at the time, before the ANC was dethroned from power in February this year. So let's not elevate it to something, oh no, no, it's a political decision. Some of those people didn't even know what was happening, they just vote. Hey, siang up, oh, and then they vote. And on the basis of that, you want to condemn a person for life beyond the grave. Beyond the grave. You have condemned him, you have vilified him, you have booted him out of his job, and now you go to the grave to dig the grave and say, I want to kill you again. That is what's happening here. Let's not glorify it with these pieces of paper. That is all that is happening. It's a lynching of black people in the same way that lynch mobs were doing in the South, in the United States. You want to lynch someone and not be happy with killing them, but you must hang them on a tree so that passers-by must see his body hanging like this. And you call it the rule of law. The rule of law, my foot. It's not the rule of law. It's the law of the jungle. And we're not going to have that here. So when we return, I'm going to ask my Leonard Jr. He's going to deal in the structure that I suggested in the heads. It goes something like this. We deal with the preliminary points. Then we deal with the requirements for interdict. And then we deal with the merits. That's kind of the broad structure. And I want to say this, that the merits will only deal with them in the context of what, and that's why this case has just been turned upside down, unfortunately. The merits of this case we shouldn't be dealing with, properly speaking, but only to the extent that in the EFF versus Godin case, they say you must have a judicial pick. You are allowed, as it were, a judicial pick into the merits, but only for the purposes of determining whether the interdict should be granted. That's really all. But because of the chaotic structure, which I will deal with when I deal with the abuse of process. It looks, actually we started at the tail end. We started by dealing with part B, which we shouldn't even be reaching. So Mr. Moela is going to deal with two things. One of the preliminary objections, you'll remember, is the one that talks about the incomplete pleading, which says outer was not pleaded. So he's going to deal with that in that context of the non-pleading of outer. Because in our respectful submission, that should be the end of the case. If you don't plead an essential amendment, that's the end of the case. But if we're wrong, then he's going to deal with the requirements of interdict to show that in any event, the outer requirements have not been established. Assume they were properly pleaded. So that entire section will deal with it. So that will leave me to deal with the remaining points in limine, which is abuse of process. Locus standi I'll touch on. Agency I'm not going to deal with because there was a suggestion, although I'm going to say something about the full application regarding agency. And then I'll deal with what I call the peak, the judicial peak into the
Yes.
You must take our tea time now.
yes. We can take the tea.
Court adjourns tea.
dismissed on the basis of constitutional. We're going to set it out again in the High Court. And the reason I'm raising this is for the court to understand that there are no barriers to the National Assembly, especially also given the differences on what constitutes gross misconduct, if that issue were to arise. Because there are, amongst lawyers, there are dissenting views on it. And the JSC's dissenting voice was even larger. It was 4 to 6, if I recall correctly. Mr. Katz dealt with the issue of composition. Why interdicting Judge President Hlophe would impact on the composition. I do not intend to deal with that. I merely support what he said, but point out the case, and I think he did refer to the cases, the Judicial Service Commission versus K-Bar, 2013, Volume 1, SA 170. And the relevant paragraph there that I would commend the court to is paragraph 27, which deals with the composition. If Judge President, if Dr. Hlophe is removed, the consequence is going to be that the matter is remitted back to the National Assembly. There are two ways to look at it. The MK essentially would have been put under warning not to renominate him as their nominee, because the court would have said so. The court would have said some things about it's necessary for the National Assembly to do a fitness test or a suitability test of Judge President Hlophe. That it's not sufficient that he's simply a member of the National Assembly. And so MK must then look around and say, Dr. Hlophe, hey, now in light of this judgment, what do we do? You are the person with over 20 years of experience, working with the judiciary, working as a judge president, working in the JSC. Your only issue is a divided view of whether your conduct was gross misconduct. It's the issue, really, and the findings that came after that. They say that is a problem, it disqualifies you. But let's assume MK is bold enough, which it is. They say, no, we look at your experience, we want that experience. Your transformation of the Western Cape judiciary is legendary. You are the only judge in this country who was able to say with a straight face that there is racism in the judiciary. Now, and then you used your position to change things in the judiciary. And if you go to the archives of the Office of the Chief Justice, you'll find that the running of this division was commended as one of the best run divisions. So MK says, we are renominating you. The National Assembly says, no, actually it's true. We are voting for you again. There is now contempt. Contempt is coming their way. Because I can see a crafty lawyer somewhere coming up with the theory that MK's position of insisting to nominate somebody who's a disgraced former judge is in fact not consistent with the judgment. I don't know what the judgment is going to say, and I shouldn't until it's written. But what they are asking the judges to do, honorable judges to do, is to do that, to introduce in the National Assembly the tyranny of the majority, to direct how the majority should think. the majority members should think as the JSC thought with dissenting views. Remember the JSC had a dissenting view? Both the 2009 and the later JSC, they had different views about whether this constitutes gross misconduct or not. The National Assembly must be accorded that same respect of differing on whether or not the issues that pertain to Judge President Hlophe are relevant at all, other than the one issue which is relevant, his membership of the National Assembly. I've already dealt with the fact that the lawfulness of the impeachment is still a subject of pending litigation in different courts. As I said, there is no application to reinstate the Supreme Court of Appeal yet. When the funds are available, that application will be reactivated. There are no funds to raise for the appeal. So when that is done, then it would. And Honourable Justice, I just want to paint this picture. What the state placed Judge President Hlophe is inimical to the dignity of the office of the judge, because essentially what they were asking him to do was to go and look for money elsewhere. So Judge President Hlophe could go and look for money from a rich person who litigates a lot in this court and get a lot of money to litigate further his impeachment. That's undesirable. That is why we still are complaining about the fact that the state has a duty under Section 1654 to make sure that judges who face misconduct hearings are supported. Because you're not supporting the judge, you're supporting the principle of judicial independence. But that's not for this court to decide yet. And then the question that we raised is relates to whether the interdict sought would infringe on the right or privilege or freedom of speech of MPs. I've alluded to the fact that if an interdict is granted, Judge President Hlophe is under a hammer of contempt if he exercises his duties as a member of the National Assembly in the JSC. He would be in contempt. And that, not only that, if, as the scenario I postulated before, the National Assembly is dictated to by the courts, that they must ensure that a process is set up that would look at Judge President Hlophe's, at Dr. Hlophe's irrelevant history and decide based on that whether they should designate him. Let's assume they did. It has a freezing effect. It has an impact on their free speech as different parties. So we're essentially asking for an order that when the National Assembly debates the issue of Judge President Hlophe, this is what they ought to say. Yesterday it was dramatic to hear what different members of the Speaker should have been saying in advising the National Assembly. Because according to the scenario postulated by the judge presiding to the speakers to the Speaker's Council, the Speaker should have said, wait, aren't we making an error in processing this name forward? Shouldn't we consider A, B, C, and D about this man? I'm paraphrasing it with respect. But firstly, that's what happened. But secondly, the interdict would have an effect on the rights of the members of the National Assembly in their capacities. There are various capacities, and they in the National Assembly they are honorable members. But we all here can't vouch whether they are saints or sinners or what. There is a mixture of different people from different experiences of life, and that must be that must reflect. It must be the case that the House is comprised of different people from different walks of life, different experiences, and all that. That must be the case. But I would commend this court to a judgment of the Constitutional Court, the DA versus Speaker of the National Assembly, 2016, Volume 3, SA 487, from paragraph 11.
Those who are not familiar or who are not aware of the case, my name is Mngoni Mkhonto. This is the Royal Opinion. Click the like button and subscribe. The case is about Judge President Hlophe. It's about the GNU, the DA, taking the MK party to court, taking Parliament to court, because Parliament have agreed to the MK nomination to the JSC, the Judicial Service Commission. The Judicial Service Commission is a commission which looks after the legal interest of the country. So the Judicial Service Commission is the commission which sits to look at the legal interest of the country, to monitor whether laws are implemented correctly in South Africa. So the MK party have gone to election, won the election, and then have through their rights to nominate whoever they want into the Judicial Service Commission. They have nominated Judge President Judge Hlophe for him to be part of the Judicial Service Commission. So the DA does not agree with the nomination of Judge President Judge Hlophe into the Judicial Service Commission. They don't agree because it stands for transformation of the judicial. That's basically why they don't like Judge Hlophe. Judge Hlophe stands for transformation of the judiciary. It stands for making the judicial Africanizing, what he calls Africanizing the judiciary. Judge President Hlophe, Judge President Dr. Hlophe, advocate for changes in the legal, for transformation in the legal fraternity. He advocate for the law to be Africanized. I mean, for the Roman Dutch law to be incorporated into the African law, what white people call the law of the jungle, which is neither here nor there, really. So the DA have taken the case to court because they lost in Parliament. Majority of the Parliament voted that Dr. Hlophe can go to the Judicial Service Commission to serve his people as appointed by the MK party. So, but the DA does not agree with this, so they want him removed. So I'm just giving the background for those who are not aware. The DA have got a power to choose. Helen Zille have got a power to choose the leaders of black people. They have power to nominate, to remove leaders of other political parties whom they don't want. For instance, President Zuma, who leads the MK party, has been removed as to lead, has been prohibited to lead MK party in Parliament because of the Democratic Alliance and the IEC, which wanted him removed from the list of people who are supposed to go to Parliament. So the DA does have the power. The argument of the lawyers, and especially the argument of Advocate Dalimpofu, who says rationality should apply, and who says the DA goes to court because they have failed in Parliament. The Constitution allows the DA to go to court when they fail in Parliament. That is why the decisions of Parliament can be taken to court, because we've got in South Africa, we've got constitutional supremacy, not parliamentary supremacy. If Parliament would make decisions and courts were not allowed to, it talks very rational issues. Courts, there's supposed to be separation of powers, but there can't be separation of powers when the courts are the ones who are making decisions for Parliament. It can't be separation of powers. So every time when the DA or when the minority fails in Parliament, when they can't get their way with the majority, they always have the judicial system, which they have already manipulated to their favor, for them to be able to fight their wars through the judiciary. So the judiciary, having been captured, the judiciary does come up with solutions. They always win, because this is a corrupt, it's a corrupt, generally corrupt judiciary which acts on behalf of white people in one way or another. It serves white interest. It has got nothing to do with black people. So the DA, knowing that we've got constitutional supremacy, whatever decision that Parliament makes, they are not worried about Parliament, because Parliament is a small thing for them. They can take it to court where they've got their 11 people whom were appointed by them, whom are accountable to them, not accountable to people, whom were not voted by the people, to make decisions about the country, to make final decisions about whether the decisions that were taken in Parliament are sound or not. These are the people who are taken to, who are basically taken to make decisions about if it's parliamentary supremacy. Parliament is the people who are given the opportunity to make decisions about the country. So now, when it's judicial supremacy or constitutional supremacy, then it means the judges are the ones who are superior in the country. They are the ones who will make decisions on behalf of everybody else. So otherwise, what they're arguing will not be able to legally convince the judges, not because what they are saying is not convincing, because legally the DA is allowed, which is nonsensical. The DA is allowed, or any other organization is allowed, to take Parliament to court. It means any organization is allowed to take the country to court, because Parliament is a representative of the people. So any organization is allowed to take the people of this country to court, which is nonsensical. When the owners of the country make decisions about their own country, they should not be taken to court to account for anything, or they were supposed, all decisions were supposed to be implemented. When the majority says this is what should happen, the majority should be listened to. So not the minority ruling through the courts. At the moment, what is happening is white people are leading South Africa through the judiciary, When they fail in parliament, they go to the judiciary. Remember, parliament as well, it's captured. Most political organizations in parliament are captured. That's why we don't have the expropriation of land without compensation, even up to today. The judiciary is captured. That's why the judiciary will not make decisions that will impact positively in the life of black people. It will always make decisions against the majority in order to take care of the minority. So these are the foundation or the arguments of the lawyers in court. We can go on and listen to the arguments. Dalimpofu was arguing, Advocate Dalimpofu was arguing mainly about separation of powers, saying when Parliament have made decision, then the judiciary should not overturn the decisions of Parliament. But in law, the judiciary is at the moment allowed to overturn the decisions of Parliament. In the apartheid time, when white people were leading, the judiciary was not allowed to overturn the decisions of Parliament. That's how white people were ruling against the people's will. So now, when they took over, when the ANC, when they put their slaves in place, when they put their slaves in place, they then removed that law in order to further protect themselves, so that Parliament does not have teeth anymore. All the decisions of Parliament can be challenged. So Parliament is not an institution. It's not basically people are just going there to play. They can't make any decision. The decisions have to be made by the courts. It's better that all the issues goes to courts and courts deal with the issues, because at the end of the day, the Parliament cannot make any decision. The court can decide otherwise if they want in any of the parliamentary decisions, which is a problem when the constitution becomes superior. Then the minority becomes superior and the majority becomes inferior. That's what is currently happening. That's how they are maintaining the apartheid structure in South Africa. That's how they are able to maintain the apartheid laws through this corrupt judiciary, bought out judiciary, through these corrupt politicians who pretends like they are acting on behalf of people while they are acting on behalf of their pockets. That's how these people have been. President Ibrahim Traore calls them the house slaves, the charlatans, the house slaves. In America, they call them the house Negroes. The house Negroes. That's what they call them in America. What do we call them in South Africa? We call them Impimpi, or the collaborators. Those are the collaborators with the apartheid system. So I like to call them the slave traders. The slave traders are the people who are sent to parliament to take care of the needs of the people, but end up taking care of the needs of the minority and ignoring the majority. Those are the slave traders. They are appointed on basis that they are able to gather the slaves. They are only appointed on basis that they've got the ability to gather slaves in one place and control them and control the slaves. That is their basis for their appointment. So let's go on and listen to the argument of the lawyers as we analyze.
Justice Madlanga, writing for the majority, says South Africa is a constitutional democracy, hard-won democracy that came at a huge cost to many, a cost that includes arrest, detentions, torture, and above all, death at the hands of the apartheid regime. The importance of our democracy, therefore, cannot be overstated. It is the duty of all, in particular the three arms of state, jealously to guard that democracy. Focusing on Parliament, the pluralistic nature of our parliamentary system must be given its true meaning. And if you want to read further down, it's brilliant in how it explains the role of Parliament and how Parliament must be left to its devices. The only thing that makes Parliament a parliament of the people is its ability to debate freely issues that pertain to it. But in this inquiry that is postulated, this ad hoc committee that is postulated of the National Assembly, what are the rights of Honorable Member Dr. Hlophe? Or does he appear there and say to them, guys, you're worried about my eligibility. Let me tell you who I am. This is what I've done. This is where I have. This is what I have.
Let's click the like button and subscribe if you are new here. You can also support the channel through super chats, super thanks there. You can super thanks me and the channel for growth. Click the like button and subscribe.
Is that how our National Assembly is going to function? Well, the Constitution doesn't say that it should have functioned that way, because it simply says you're a member of the National Assembly, you can be designated to a body like the JSC. So this part of the judgment from paragraph 11 to 17 deals largely with the issue of of Parliament and why it is a body that should really have the freedom to debate issues and to reach the decisions that it reaches. We say that an interdict against a member of Parliament would really be just inimical to our constitutional scheme, because what you are saying to the judge is that he cannot perform functions that he is assigned by the Constitution to perform in terms of the Constitution. You are not simply stopping him from going to the JSC. You are stopping him from performing his functions as a member of the National Assembly in relation to matters that have to do with the JSC.
That is the whole purpose. The purpose is to stop him from saving his purpose as a member of Parliament. That is the purpose. The purpose is to for the DA to be able to select the leaders they want to lead the MK party. They want to remove Judge Hlophe as the leader of the MK party in parliament because they know he means what he's saying. He wants to support the MK party and President Zuma to liberate black people, so they don't want him in parliament. The purpose of all this is to remove Judge Hlophe from doing his role as elected by the MK party.
So, the National Assembly would perform its constitutional obligations if it were directed to do so under the hammer of contempt. If they don't perform the functions this court says it must perform, they are likely to be held in contempt. And we say that is an effect on the rights of the National Assembly at different levels. I want to then deal with this notion that's been raised by Corruption Watch. It's similarly been raised in heads of arguments by Freedom Under Law. That the reason why you ought to intervene in the affairs of the National Assembly in relation to its designation of Judge President Hlophe is because Judge President Hlophe is unrepentant. Judge President Hlophe has not repented. Now they haven't told us which altar he should go to in order to repent. They haven't told us which God he must go to in order to repent. Well, the Constitution perhaps. But it's an extraordinary submission to make in light of what Judge President says, sorry, in light of what Dr. Hlophe says in his affidavit about his commitment to judicial independence. DA will never believe that Judge President Hlophe his commitments are valid, and they may have reasons for it. Well, similarly with the FUL. But under oath, Judge President Hlophe says, I'm going to use this position I have to promote.
Yes, you make it.
As the court pleases. Then, I just said that other requirements, they are really badly pleaded. Because if there's no harm, that means we can't intervene. If the harm is not suffered by the DA, you'll find that in paragraph 68 of the DA founding affidavit, case line 01-27. That's what they say. I mean, that's the same mistake that Corruption Watch does. At paragraph 91 of Corruption Watch founding affidavit, they said it crudely, we rely on section 33. They were so crude than the DA. The DA obviously tried to play with some fancy words. Corruption Watch said we are relying on section 33. That's what they've said, and the rule of law.
38. Is it 34?
I beg your pardon?
Where is the line of 34?
Their paper says 33.
Well, they argued they said 34.
I'm not talking about their argument, I'm talking about their papers. So we
They
are
argued they said 34.
pleading. I'm talking about what they've pleaded.
Okay,
When they argued that they said 34.
yes. Can you,
Let me read paragraph 91.1 of the Corruption Watch founding affidavit under the heading prima facie, and this is what they've said. Firstly, you won't find any 34 in the paragraph. Firstly, section 33 of the Constitution. That's what they're relying on. Section 33 of the Constitution, which provides that everyone has a right to administrative action that is lawful, reasonable. So we can forget about their argument because you don't plead the case through the arguments. You plead the case through the papers. That's the right they are asserting. They must be found, like I've said, they must stand and fall by their papers. They can't stand by their counsel arguments, not even under oath for that matter. Then they dress it with the principle of legality. So there's no, you can't, this is why you must find that particular aspect. Then, now, I'll then deal with the alternative remedy. In the aspect of alternative remedy, may I proceed, Justices?
Just 1 second.
oh, yes. Without the conflict.
Because they quickly fixed it. Just
Click the like button and subscribe. Let's click the like button and subscribe. The young lawyer
Yes,
there
you can
you will.
proceed, Council.
Thank you, Madam. Then now, I was then jumping to the issue of alternative remedy. Obviously, they simply assert that there won't be any alternative remedy if you don't intervene. But we plead that there are alternative remedies, and we list them. That these are the alternative remedies. You'll find such at paragraph 124 of the MK answering affidavit. That is -06. That is 06-38. That's when we find the suggestive alternative remedy pleaded by MK. So the duty then was triggered for them to reply in the replying affidavit to say that these are not competent remedy. They must tell this court why they are not competent, because MK dealt with that in their answering affidavit. They dealt with what Mr. Masuku also addressed, that you can run for election or sponsor a constitutional amendment. You can seek a review of the relevant established convention in terms of Rule 9 of the National Assembly. You can lodge an interim interdict against the MK or the National, or even the JSC, or you can write a letter to Dr. Hlophe. So these are alternative remedies. So there was a duty to then say to court that these are not effective remedy. And that has not been pleaded. So I'll just pass that. So now the last requirement of Sitlogelo.
Are these remedies that they can be employed before the next sitting of the JSC?
I beg your pardon?
Are these remedies that can be employed before the next sitting of the JSC?
Yes, you can seek. They're seeking a review now before the sitting of the JSC. Paragraph 124.2 speaks about seeking a review of Rule 9 of the Constitution.
No.
So it can be done before that. And then 124.
That's not my question.
Yes, no, I was going to point out that was not the question.
Oh, no, I apologize if I missed the question. Can I just get maybe the rephrase of that question?
Yes.
Yes.
My question was, are these remedies that can be employed before the next sitting of the JSC? Because you're suggesting alternative remedies, that there are adequate alternative remedies available in this paragraph.
Yes.
So go through it and explain to the court why you're saying they can actually employ these ones before the next sitting of the JSC.
Going for the elections and so on, as
Yeah.
you're reading from your paragraph 124.
Yes, paragraph 24 says seek. Let me start by just answering. Let me give two answers. One, we are here because it's a review, and that review is happening before the sitting. So, and that's why they are approaching this court at least. They are coming to court before the sitting. So what we tell them here is the review, that they can still come before the sitting. So there's no special review than the other. They are all review, and they can all happen before the sitting. So that is a simple answer to that.
No, I don't understand it like that. Remember, these are you filed a composite affidavit in answer to the 3 applications that before court. So the requirement in question relates to the 2 applications where they seek an interdict,
Yes.
an interdict. So the question is, you're saying there are alternative remedies. Because they must persuade the court there's no alternative remedies available to them, and therefore the court should grant the interim interdict. Not so.
That's what they assert.
So you are saying there are alternative remedies available, and you list them here in paragraph 1 to 4. So the
That's
question is, can they employ these alternative remedies? Can they sponsor a constitutional amendment? This is not before the next sitting of the JSC. Can they seek a review of the established convention in terms of Rule 9 before the next sitting of the JSC?
Yes, FAL has done that. They are
Can
seeking
they
a full
lodge-
review.
Sorry? Can they lodge an interim interdict against MK before the next sitting of the JSC?
Yes.
So what I'm saying is go through it, and can they actually employ it? That's what I want you to discuss.
Yes, they can actually employ that. And it must be, firstly, let me then say that they must be the one to demonstrate that these remedies are not competent. Because, we are confined to the 4 corners of the pleading. So if we are saying that we were making an assertion, it must be countered in the papers So they don't counter that. So from that point of view, we must accept that they've accepted them as remedies. Because if they don't say anything, otherwise they would have contested. But just to come to your ladyship's question, the interdict of the National Assembly, remember what they've done? They've tried to circumvent interdicting the National Assembly, but they say that inevitably that's going to be the consequence, that National Assembly will not be able to implement its decision. So we are saying because National Assembly is not interdicted, they could have interdicted the National Assembly. It's an alternative remedy. And I don't think that I must stress it further than that. And just to add on the issue of Rule 9, because I was doing Rule 9 review with pari passu with FAL, but they can also do it with an interim as well. So they are not forced to simply come for a full review. They can do a Part A and Part B to win Part B in terms of Rule 9 review. So that's an alternative remedy. They must demonstrate that how inadequate it is. And they say nothing about that. Then now, I'm just looking at the issue of time. I'm trying to reserve some time for my learned senior so that you can, because these points, they are interrelated. So some of the points is going to demonstrate in a great length. Then, let me then go to the outer requirements as the merits. Because the outer requirements establishes additional requirements to Sitlogelo. If Sitlogelo has 4, if you add outer, then notionally you have 8 requirements. 4 plus it must be in the clearest of cases. It must safeguard the separation of harm. It must be in exceptional circumstances or exceptional case, and then there must be demonstration. All what must be
is paragraph 27, which
Click the like button and subscribe. Click the like button and subscribe. This is the Royal Opinion. My name is Ngoni Mkonto. The topic today we're talking about the arguments of the lawyers about which is what black people normally go through, so unnecessary suffering on the law, unnecessary in a way, because that's what what they do is they take you to court.
deals with the
They take you to court just in order to exhaust you because they have the money. They take you to court. If you represent black people genuinely, they just take you to court just to exhaust you. We blacks really owners of the country. We will win this war. Tando Kumalo saying, we blacks really owners of the country. We will win this war. It will take. It's going to take a little. It is a bit of more strength, more energy for us to win the war. This is a well-established enemy. We're not talking. We're not playing games here. We're talking about people who are serious and who knows their stuff. We're talking about colonial masters. This is a colonial battle. These people are fighting to colonize, to keep on colonizing Africa. Our fight against these people, it's not a game. They have already established themselves using our resources. They've established themselves using our money. They have established themselves using our taxes, our energy, because that's what we do. We pay taxes, we pay VAT, we don't even know why we pay, and all these monies are paid to international corporates in businesses. In actual fact, at the end of the day, all of these monies that we pay as taxes will end up in the pockets of a white business at the end of the day. Whatever amount that we pay as taxes will end up in the hands of white people. So the war of liberating us as black people in the whole of Africa, it's not gonna be an easy war. These people are determined to fight, and they reasonably so. They will not give up these resources just easy like that. It's quite a lot of money that they are making out of the suffering of black people. So they have the power to choose who will lead black people. Some of the people who are joining MK party may have been sent to be spies in the MK party from by the white system. That's why we always have to open our eyes. We have to be careful, because that's how they operate. We can't identify them, because now they look like us. They are able to buy people who look exactly like us to represent them. So we get confused that in actual fact it's us who are implementing these decisions, while in actual fact the people who are implementing all these negative decisions against black people is the white system which is in place, the colonial masters, the queen herself, who owns South Africa, the imperial masters who are the USA, who owns the business and the resources of South Africa, who owns our gold mines, who owns our platinum mines, our chrome mines. All of the things that we are producing in South Africa is not owned by the people of South Africa, is owned by by foreigners, by people who came to kill and loot our resources. They continue to do that. They continue to kill and loot our resources. We
still are complaining about the fact that the state has a duty under Section 1654 to make sure that judges who face misconduct hearings are supported. Because you're not supporting the judge, you're supporting the principle of judicial independence. But that's not for this court to decide yet. And then the question that we raised is relates to whether the interdict sought.
AfriForum, this side, FUL, Corruption Watch, all of them against one person, all at the same time. And they claim to represent the public. The public. So why is the public? There's one public in South Africa. So if that public has been represented by the DA, why does FUL also want to represent the same public? And Corruption Watch wants to represent the same public? And AfriForum wants to represent the same public? It's pure harassment, deliberately planned, coordinated attack. And, they don't hide it, which is very good. FUL tells you, they say, we are aware of the DA application, but we're bringing our own. Corruption was the same, but bringing. We are even aware of the AfriForum decides to go to the Constitutional Court. It's a clear strategy to impoverish these respondents, because they must do an answering affidavit this side, and then there's another deadline, then the Constitutional Court, and for what? Just because they lost the vote in the National Assembly. We must bring judges from other provinces and everything. For what? To waste our scarce judicial resources because somebody lost a vote. And then we say, I'm sorry, Justice.
Before you depart from that,
point, yeah.
Mr. Mpofu, does that, well, yes, you are submitting it constitutes abuse,
Yeah.
but maybe in a more technical way.
Yes.
Does that exclude their right to act in terms of 38D?
No. That's not what I'm saying. Sorry, Justice. No, I'm not saying that.
Yes.
I'm saying they even have a right to act in terms of 38A. Just like Mr. Zuma had the right, nobody, even in your case, you never said he didn't have the right to go to court. No, he did have the right to go to court, but he said in going to court, it was an abuse of the process. So let's not conflate the two things. Nobody, even in all the Hudson, in all those cases, nobody said, no, you shouldn't, you don't have, you are the special person who doesn't have your constitutional right. No.
So they do?
They do, of course. They have everyone, all of us, you, me, the NP, what you call the thing, SPCA, everyone has a right.
Yes, what I am trying to understand is then the abuse lying in the almost simultaneous.
Yes, on this aspect. On this aspect, I'm saying yes. As I said, former President Zuma says in his affidavit, they hunt in packs. So it's not some one day, like was suggested yesterday, FUL brought an application, and then, by some coincidence, the DA. No, this is coordinated. They say to you, we're all coming on the same day, and we're aware of the other application. If you're aware of the application, why do you need another application? That's what you must ask in your first place. There's only one Hlophe. If he's going to be removed by the DA, he's gone. Why do you want another application, and another one, and another one? So that's a clear strategy, because they have money from the foreign funders that they have. They can do that, but Dr. Hlophe and MK don't have that kind of money.
Yes, I just wanted to understand.
Yes, no, I understand the question. And we say that it's hypocrisy, because all this comes from this thing of the so-called rule of law. The rule of law is another red herring that gets bandied about. That thing is meaningless. There's no such thing, actually. It should be thrown out of the dustbin. Because apartheid was the rule of law. The Group Areas Act was the rule of law. The Separation of Amenities Act was the rule of law. So there's nothing magical. The rule of law must be good in its own right. You can't just go and fly some flag from racists who tell us about the rule of law. Now, number 5 in our thing, we say MK feels strongly that these busybody applicants who claim to be the enforcers of the rule of law are notably silent when black women are murdered in cold blood by members of AfriForum and fed to their pigs, and many other criminal transgressions suffered by black people and the country at large at the hands of their puppets. Now, that might sound to be an emotive submission, but it simply says that the court lives here in South Africa. It doesn't come from the sky. We know that there are certain causes that are ignored by these people. And there are certain causes and people who are pursued, as I said, beyond the grave by them. And former President Zuma lists examples, I won't go into that, of how he personally, in his affidavit, how they came, the PEC came when he was supposed to be paroled. The PEC came when he was bringing another matter in the case at end. The PEC comes whenever these things happen. And it must end here. You know? So the court must not allow its machinery to be used for those kinds of purposes, for political purposes in this case. Just as in the case I was saying, what really the court was saying in the case that Your Lordship was sitting in, was that the process of the court was being used for political purposes, in effect. Forget about the ANC conference and all that, but in fact it was saying the court process was being used for political purposes. So, and I'm saying this, if that is true, was true in that example, this is 1,000-fold of the court being used to pursue political objectives, particularly political objectives that people have failed to succeed in the democratic parliament. And then we say that, so just one by one, Corruption Watch, I've already made the point about the multiple, we've just debated the multiple applications. FUL is even worse, because we say their application is clearly not ripe. That's the point I wanted to make yesterday, and I was stopped from making it, and I feel that let me make it now. What we were trying to say yesterday, Justice Park, is that you cannot, and when we do, our objection was that the FUL application does not belong here, and we can't bring that objection later, because it's a point in limine, in the proper sense. In limine is just some fancy Latin. It just means at the threshold. So it must be raised at the beginning, because you need a ruling on that, just like we did with the emperor. And in the case that Justice Collis did, the ZEP case, that's exactly what they did. The whole issue was Part A, Part B, then it says in the judgment. Then the court, it was raised, then the court took a short adjournment, and then it came back, and then it said, okay, we will proceed with Part A. It couldn't have done that at the end. You can only do that at the beginning. And that's how I was distinguishing that point in limine from the other points in limine which could wait, like abuse of process and whatever. But be that as it may, the point of the matter is that it is completely ludicrous to have an application and hear Part A and Part B on the same day. And it's just... And in the case of AGVH Holdings...
yes, but remember just one thing, Mr. Hlophe.
Yes, Justice.
Your words, you can't hear Part A and Part B in one day.
Yeah.
What has happened here is at the risk of repeating myself, in respect of the DA and the Corruption Watch cases.
The Part A cases.
Yes, Part A cases. And in respect of FUL, you might call it a Part B. But these are separate applications.
Yes, okay.
They are being heard on the same day. But it's not like a simultaneous in the same case.
No.
Yes. So that's what the inspiration. So we are not hearing Part A and Part B, and that calls for a different funding for the different cases.
No, I'm sorry.
In order for in our judgment.
Yes.
So we will have to say something about each one of them.
Of course. Yeah.
But unless your submission is different, but in your words, when you say, but no, you can't hear Part A and Part B at the same time. That's not what we
Okay, let's forget maybe it's the part thing that is confusing. Forget about parts. You cannot there's no court in its right mind that can hear an application pendente lite. That's Latin for pending litigation. You can't hear an application pendente lite in the lite and the lite itself on the same day. That's this is how it was described by, because I don't want to use words that come from me, Binsward J in this court. In that case of
Give us a citation.
HAVH Holdings, my lady, and versus Steinhoff. It's the Steinhoff, the big Steinhoff cases. It's 872 unreported 8276/2018, and then square brackets 2020 ZWCHC 46 bracket 4 June 2020. And this is what he said. It does not appear to me, paragraph 16. It does not appear to me to be in any sense fitting or appropriate for action for interim relief pending the determination of a principal case, whatever you call it, the principal case, to be consolidated with the action in that principal case so that both actions can be determined contemporaneously. Merely stating this proposition shows it to be a nonsense. There cannot be any prospect of interim relief pendentally being a real issue deserving a court's attention if the case for it is to be decided together with and at the same time as the principal case. Nonsense, he says. So why does he say that? Because by definition, and this is what I wanted to read yesterday morning. By definition, if you say, you see, Justice Parker, your example could work if there was some coincidence of cases. Here they tell you we know that there's a Part A case. Actually, not only do we know, we're asking to please hear it on the same day. But we're only going to ask for what is the main relief in that. Call it what you like if you don't want to call it Part B. But we're only going to ask for that, the main relief, in other words, the review of the main relief in the DA. But let me just assist the court really with to cut this to the chase. This application that they say they are aware of the DA says at paragraph 64, and you'll find that quoted at 17.3 of our heads. The DA accepts that it will not obtain final relief in Part B before the October interviews. Even if it is able to obtain a determination by this court, any judgment will be appealed, and it is impossible that all appeals will be resolved before 7th October 2024. Impossible. They don't say difficult, unlikely. It's impossible. The DA also accepts that the final relief, you call it what you like, final relief it seeks is of public importance, that the respondents must have a proper opportunity, that's us, to answer it, and that it should not be determined hastily. I never thought I'd praise the DA, but here, they are right. They are very right, that we must be given an opportunity to deal with, I'm sorry, Justice to deal with such a matter, and not be slapdashed here and dragged to listen to a presentation of the main presentation. Sorry, Justice.
I think one must understand what has happened here. There were the three applications. The deputy or the acting Justice President of this division made an order, and apparently by agreement, we were not there.
I was there.
These three applications be heard simultaneously. And you agreed to that, well knowing that full is asking for final relief and the others for interim relief. Now the proposition is correct, is that it would be wrong to make final relief and simultaneously interim relief, because it cannot work. We'll have to consider that. And that's why your protest was raised yesterday, and we said, let us deal with it on the basis that everybody gets the opportunity to argue the matter. We eventually, when we've got to give a judgment, we'll have to sort this out.
Yes, no, Justice, I'm with you. All I'm saying, I'm not, that's what's under the bridge, whatever happened yesterday. I'm now doing what I was told I must do tomorrow. It's tomorrow now. So I'm saying that and I take your point, but surely, Justice Tafu, you know, just from your own experience as an acting DJP, that the case management. In other words, if I go to case management to your chambers with my learned friend, and I say, we then agree, no, the matter will be heard on Thursday or Tuesday or whatever, it doesn't mean I'm not taken away my right to object, to say this application should not even be here. So we can't, let's not confuse the case management, and I agree that was done and so on to get but it can't take away now our right to object to what has been described by this court, this very court, as a nonsensical approach. And the point, I'm sorry, Justice.
We know, for example, that MK hasn't responded paragraph for
to the
paragraph
merits. Yes.
To Fool's application.
Absolutely.
We've seen that.
Yes.
And obviously that is something that will have to be considered by us when we write a judgment
yes.
here.
Absolutely.
So I don't think we should carry on with this point any further. We understand the difficulties with this. Fool wants a final order today, whilst the others want interim relief. And we are mindful of that issue.
No, Justice, please forgive me. You might be mindful of that. But remember, I'm raising this in the context of abuse of court now. I'm not raising it for these procedural quibbles. I'm saying that to do that knowingly, knowing that it has been described as this, and to persist. You remember what we say in the MK affidavit? We say that we're not going to deal with the full affidavit. We ask for them to withdraw it, failing which we will do what I'm doing now. Point it out to be an abuse and ask for punitive costs. And they failed to withdraw it. That was friendly fire. Yes, we were saying yes. Yeah. So I'm raising it only in that context, but I take the point. I'm sure the court, even the questions you asked from my colleagues, I know the court is alive to this issue. So I'm not raising it from that point of view. And what I really want to emphasize is the fact that they say we are aware that there's a DA application. The DA application says we must be given proper time if we're going to deal with these complex times. But they say, no, we're going to court anyway. That's abuse of us. If the court wants to be abused, that's fine. But we don't want. We don't want to be abused like that.
Abuse either.
Thank you. I would have thought so, my lady. But I just have to speak for this side of the table. Okay, I want to, the mineral sands I've already referred to. The DA, I've already said how they abuse, because they are the worst abusers, because they were in Parliament. I mean, the others, you can say, well, they're NGOs, what else must they do? But those ones who are in Parliament and then come and want to abuse the court to be, as I say, it's appeal tribunal. Now let's quickly deal with the issue of jurisdiction. If I'm correct on the abuse of court, of course, that's the end of it. Now, very quickly, my learned friend, Mr. Katz's issue on everyone is against him. Well, he must try and trade places with me. Well, that's what I do for a living, to be lambasted and vilified for representing people. So I don't have much sympathy with him. Now, the only reason that we part ways with Mr. Katz on the jurisdiction is simply the following. And I had a debate with him after court. Mr. Katz is, if the thrust of this case was the designation in 178(1)H per se, then Mr. Katz would be correct. in other words, if the crux of the attack, I know that 178 features strongly, and I'll deal with it. But how the applicants have pleaded the constitutional obligation issue is that they have based it on section 165.4 and 165.3, I think. So they're saying Parliament failed in its obligation to uphold the independence of the judiciary. That's really the crux of the obligation attack. Now, if that is true, then that power says all organs of state must do that. So it's obviously not a power that's specific to Parliament. It's all organs of state. So therefore, from the Nkandla case, it has been said that if the power is a generic obligation that Parliament shares with other institutions, then you can't say it's exclusive jurisdiction, because that 167.4e must be restrictively interpreted. That's the main issue why we differ with Mr. Katz. But also Mr. Katz is wrong on another point, because he also says, well, what if the Constitutional Court, they go to the Constitutional Court, and the Constitutional Court also finds that it doesn't have exclusive jurisdiction? But as we all know, in the Constitutional Court, there's another route to get in. If you don't have jurisdiction, exclusive jurisdiction, you can get in through direct access. So that wouldn't be such a crisis either, because in any event, it has been pleaded by AfriForum, I think, as an alternative. So that's why we say this court has jurisdiction. Apart from that, and let me dispose of another easy issue, PAJA. We also say PAJA doesn't apply. PAJA doesn't apply. We know that also that doesn't necessarily present a crisis, because if PAJA doesn't apply, you can go legality. But it's important for the purposes of this case to make it clear that PAJA doesn't apply. And Mr. Trengov gave us the definition of PAJA, but he fell short of one aspect. We base this, there are many reasons why PAJA doesn't apply, including the fact that the DA is not asserting a right and so on. I don't want to go into those esoteric reasons. I want to just deal with it at the level of the exclusions. PAJA says that in section 1, administrative action means any decision taken or failure taken by an organ of state or a natural juristic person, we know that, but does not include. And Mr. Trengov dealt with the first exclusion with his, the legislative functions of Parliament, a provincial legislature or a municipal council. And he says, no, these are not legislative functions. But that's wrong. Legislative functions doesn't mean just creating legislation. It means the legislative function that's been defined in the Fairdshaw case means that the businesses of Parliament acting as a deliberative body. I'm just paraphrasing the phrase. And in this case, Parliament, clearly we've seen from Hansard, was exercising its powers as a legislative body and a deliberative body. So we say that's a first exclusion. So PAJA cannot apply to those. PAJA applies if the legislature or the president or whoever was doing an administrative act, not a legislative act. But let's assume we are wrong on that. Go to the other exclusion, which they haven't dealt with, GG. So GG says PAJA excludes a decision relating to any aspect regarding the nomination, selection, or appointment of a judicial officer or any person by the Judicial Service Commission in terms of any law. How can it be clearer than that? Any decision relating to any aspect regarding the nomination, selection, or appointment of a judicial officer or any other person by the JSC is excluded specifically from PAJA. So
yes, but is that applicable? I mean, at
In
the
this
end
case.
of GG, it's by the JSC.
No. Of any person, not. The by the JSC talks about to the appointment, not to the governing sentence. I'll explain to you just now, Justice.
Yes,
It
maybe.
says,
Just reread that.
Yes, so sorry, yes, let me do so. A decision, right, so that's the administrative quote unquote, let's say it's administrative decision, but it's excluded, yes.
Yeah.
Relating to any aspect regarding to the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commissions in terms of any law. In other words, the decision must not be confused to the appointment. It's a decision relating to the appointment by the JSC. Yes.
It's clear it's a decision by the JSC.
Yes.
It's
Yes.
not by another body.
Yes, by another body, but relating to an no. I think we are completely at cross purposes. If I say there's a decision, let's say there's a panel of cricket selectors. Now you say any decision that relates to the appointment of a person by the cricket selectors. It doesn't mean it's a decision of the cricket selectors. What that is excluded. It's any decision, administrative decision relating to that second step. It's very clear.
Who is the decider in this GG section?
It could be any. In this case, let's make it concrete.
Yes.
It's the NA, National Assembly. So the National Assembly takes a decision that relates to any aspect regarding the nomination or selection or appointment of a person by the JSC. Okay?
Yes.
So that's what it means.
Mr. Mpofu, you have highlighted that, so I don't think we
No,
need to
yeah, the judges are thinking, yes,
for
no, there's no point, yes. I think in good time, the judges will engage with the GG. Section 1, GG, that's all. And it's explained, in Hoekstra, it's explained somewhere in the text, that exclusion. Right. So it's excluded by, is it DD, the first one, DD and GG, I think. This is not a part of thing. But as I say, that doesn't help us much because legality, as we know, applies. Now, which then takes us to the crux of the case. And that is this. And again, I must, at the risk